Good evening, all. I'm Will, DBA Lensler on YouTube, and tonight we're going to spend the next 70 to 80 minutes. Realistically, it's more like 2 hours. Every time I've run through this so far, I get about an hour and 15 minutes in, and only about half the slides are done. So 2 hours plus, talking you through something you probably don't want to hear about again, using artificial intelligence in your law practice. I know. You came here skeptical. That's why it says a skeptic's guide right on the title page, and honestly, that skepticism has been entirely warranted up until recently. I would argue that skepticism is still warranted, but pull up a chair, pour yourself a drink, as this will be a long one. I have a pint of bitter, and I'm going to let's finish up the last of this Macallan double cask to keep me company and my vocal cords lubricated. And let's dive in. This title does say, without getting sanctioned, and unfortunately, that's not actually a hyperbole. As of this month, there are 912 documented cases where AI hallucinations have made it into court filings. 324 of those are in US courts. 128 lawyers, so far, have been sanctioned. So, yes, this is real, the risks are real, and we're going to talk about how to avoid becoming case number 913. This disclaimer at the bottom is also important. I am not your lawyer. I do not want to be your lawyer. I am not a lawyer at all. This is not legal advice. I'm just a legal consultant. And before you do anything today that I suggest, you should check with your malpractice carrier as well as your state bar. Different states have different guidance. Your insurance policy may have specific requirements. We'll talk about some very high-level ways to do some of that research a little bit later in the presentation. That being said, by the end of the presentation, you'll know exactly what to do on Monday morning. Not a vague, ooh, I'm going to go do some exploration of AI, but actual concrete steps. You'll have an understanding of what works, what doesn't, where the risks are, and hopefully how to avoid them. Let's get started. And we're going to start with where you probably are right now, because I've had this conversation with about 200 firm owners over the past couple of years, and it tends to follow something of a pattern. So where are you right now? Based on conversations that I've had, here's what I've noticed. You've heard about the hype. Every tech publication, every CLE, every vendor that can either make its way in front of you through meta ads, through your email inbox, and through any other channel is telling you that AI is going to revolutionize the practice of law. It's going to do your research. It's going to write your briefs. It's going to make you 10 times more productive. It's going to give you a diamond-encrusted aircraft carrier and allow you to work 1 hour a week and retire to a beach in Tahiti in, 6 months or something. You've heard it all. But you've also seen the Mata versus Avianca. Mata versus Avianca? Don't know. Not really important headlines. That's the case where a lawyer used ChatGPT for his research, and it made up 6 cases. Completely fabricated them. He then submitted all of this to federal court. The judge was, perhaps unsurprisingly, did his best Queen Victoria impersonation and was not amused. That story did make the rounds, and it should have, because it was frankly spectacular incompetence. So now you're wondering, quite rightly, is this actually worth the risk? Because the downside is potentially losing your license and public humiliation, while the upside is saving some time? You're skeptical that it works as advertised, and frankly, you should be. The AI industry has a credibility problem. They overpromise constantly, partly because they need to, keep their funding coming in. It's kind of the same thing as remember when crypto was going to revolutionize everything. Remember when the metaverse was the future. Remember when we all went crazy for NFTs for about 6 months, and now some digital picture of a monkey that sold for $500,000 on a marketplace is now worth about 500 cents. The tech industry overall has a bit of a habit of selling vaporware, so your skepticism is well earned. And then finally, you're probably worried about ethics violations, because unlike most technology screw-ups up to this point, getting this wrong isn't just going to cost you money or time, it can cost you your license, and thus the ethical stakes are real. And here's the thing, all of this is reasonable. Every single one of these concerns is completely legitimate, and I am not here to tell you that you're wrong to be skeptical. I'm here to tell you that as of, originally I was going to record this in February, but as of March 2026, the calculus has changed enough that the risk of not adopting AI competently is actually higher than the risk of adopting it properly. But Before we talk about why you should adopt AI, let's be very clear about what this presentation is and isn't, and then about what AI is and isn't. So, let's set some expectations. This presentation is several things. It is intended to be a practical guide to low-risk implementation. I'm going to talk you through some specific applications, specific tools, and specific workflows. Not just theory, actually putting it into practice. And it's evidence-based. Everything that I'm going to tell you is backed by actual data. VLAIR benchmarks, ABA opinions, case law, adoption statistics. On the adoption statistics things, I'm going to throw a lot of different numbers at you that may sound contradictory from time to time. It's not they're contradictory, they're pulled from different sources and reflect slightly different lenses on adoption paths. When I tell you something works or doesn't, I'm going to show you why I am saying that. It's also a roadmap for responsible adoption. We're going to walk through a 90-day implementation plan, week by week, what you're going to do, what you're going to measure, how you know if it's working. This is, however, just a plan, and it's just a framework that somebody on the internet is telling you about. I'm a fairly experienced and hopefully well-credentialed person on the internet, but it's still just a framework. Take it, adjust it, make it yours, figure out what, 90 days is realistic for you. It may end up being 75 days. It may end up being 180. That's okay. And finally, it is a framework, just a framework for avoiding sanctions. We're going to talk extensively about verification protocols, ethical obligations, and how not to end up in a federal court opinion as a cautionary tale. Here's what this presentation isn't. It is not a sales pitch. I represent precisely none of the vendors that we are going to talk about. I am not getting kickbacks from anyone. When I mention specific tools, it's because they're relevant examples, not because someone paid me to mention them. I will put one plug in here for something that will potentially get me kickbacks if I remember to, about my day job, because we're doing a conference on AI in May. But that notwithstanding, it's also not a promise of overnight transformation. If anyone tells you AI will revolutionize your practices in 30 days, they are lying to you. They are probably trying to get your money. Real change takes real time. It takes careful implementation, and it takes a lot of verification to avoid becoming another statistic and another news article about some silly attorney who didn't check their sources. It's also not a dismissal of your concerns. Everything that you're worried about is legitimate. We're going to address those concerns directly rather than hand wave them away, because by the end of this presentation, I want you to be able to act with confidence. And finally, it's definitely not a guarantee that you will not make mistakes. In fact, I'm going to tell you right now that you will. Everyone does when adopting new technology. Everyone does when trying new things in general. Think about if you're, somebody who cooks, think about the first time you tried to make a new dish. There's probably something that you missed, that you did wrong, or that you just know you could have done better. The goal here is to make small, recoverable mistakes during a pilot phase rather than spectacular public failures on client matters. And from a context perspective, the legal industry has been burned by vendor hype, probably more so than just about any other service-based industry. Practice management software was promised, to revolutionize operations, but then a lot of them you found couldn't handle basic conflict checks. Legal research platforms that were supposed to replace Westlaw somehow couldn't find binding precedent. E-discovery tools that cost 6 figures to get implemented, and then they went and sat unused. So when I say I understand the skepticism, I do mean it. It has been earned through bitter experience, and I'm not going to handwave that away either. So with those expectations set, here's what we are going to cover today. These are approximate time allocations. I'm probably going to talk more than each of these is laid out, but we will see. We're going to start with AI basics, just 4 or 5 minutes. This is not a deep dive into neural networks. It's simply what you need to know to understand the rest of this presentation and know what prospective vendors are actually telling you and selling you. If you want to understand how AI actually works, go take a computer science course. Today, we're just going to be focused on what matters for practical implementation. And if you do take a computer science course, actually pay attention in that computer science course. I took computer science in high school and spent most of the class flirting outrageously with the teacher's assistant. But that's beside the point. Today, we're focused on what matters for practical implementation. Then I'm going to make the case for change. It's going to take 10, 15 minutes. This is where I'm going to present the data on why adopting AI is no longer optional. We're going to take a look at the real numbers, the adoption rates, time savings, competitive pressures, and Importantly, the fact that there's actually some malpractice risk to not staying current with technology. Again, hashtag not your attorney. Next, we're going to talk through the ethical framework, 8 to 10 minutes, ABA Formal Opinion 512, some state variations, as well as practical compliance. I'm not here to teach a theoretical ethics CLE. Not only am I not qualified, but that's quite boring and really not all that relevant to what we're talking about here. This is just a section of here's what you need to do to avoid getting sanctioned. Again, not legal advice, not your attorney. Then we'll get into the meat of the presentation. We're going to start with low-risk applications. That's where we're going to spend most of our time, probably talking through about 20 minutes of different ways that you can implement AI in your law practices at a low risk to yourself. We're going to walk through 9 different use cases, from internal research summarization to administrative document drafting. For each one, I'll talk to you about a few tools, the workflow, the time savings, and risk mitigation strategies for those specific use cases. After that, we're going to talk through some client-facing applications, 8 to 10 minutes. These are higher risk, but they also provide higher value. Things like contract review, discovery analysis, drafting. We're going to talk about when these are appropriate and what verification protocols you have to use. Then, I'm going to give you your implementation roadmap. That'll probably take 15 minutes, maybe 20. This is your 90-day plan, week by week. What you're going to do in month 1, month 2, month 3. By the end of this section, you're going to know exactly what to go do on Monday morning. Finally, I'm going to talk you through some resources and next steps. 4 to 5 minutes, just to wrap up where to find ethics guidance, tool comparisons, training resources, etc. If I do it efficiently, it'll be 70 to 80 minutes. We're already at about 12, so we will see. I will move quickly, but comments are open for questions, clarifications, high praise. That's about all I'm willing to take. If you want to be an asshole, I'll just, ban you. By the end of this presentation, the goal for everyone here is to have a clear, actionable plan. If you need more time in any section, pause, go back, watch it again, and that clear, actionable plan will not just be, think about AI, explore options. It's going to be a specific plan. Here's the tools, here's the workflow, here are my week 1 action items. If you walk out of here and don't know what to do next, I've failed or you didn't listen. I have control over one of those a lot more than I have control over the other. So let's start with the basics. This is the, 90-second, probably 3-minute version of what AI actually is. And this is really like the actual meat of it, not the marketing version, not the science fiction version. We started with HAL 9000. I probably should have had HAL 9000 on this one instead of the little Robbie the Robot type thing. But AI is just pattern recognition at a scale heretofore unfathomed in the minds of man. That's it. That's the core of what we're talking about today when we say generative AI or large language models or machine learning or anything like that. These threads have been trained on billions, and that's with a B, so I'm going to do my little Carl Sagan of billions upon billions of text examples. Books, websites, legal databases, Reddit threads, Twitter posts, everything. The training process is essentially, here's a sentence with the last word missing, predict what comes next. Do this billions of times until the predictions get really good and your intelligence becomes one with the cosmos. So when you ask ChatGPT or Claude or Harvey a question, what's happening is it is just predicting what words are most likely to come next based on the patterns that it learned from all that training data. And the most crucial thing to understand is this is not actually thinking. There's no reasoning brain behind this. It sounds like there is, but it's not understanding, and the distinction matters enormously for how you use these tools. A real lawyer, human being, reads a case and understands the legal reasoning. An AI reads a case and recognizes the patterns that tend to appear near certain other patterns. It doesn't get why a court ruled the way it did. It doesn't even try to comprehend or come up with a reason of why the court ruled the way it did. You can ask, and it'll give you something that sounds, maybe appropriate, but it just knows that when court talks about X, they tend to use language pattern Y. And this is why AI can be both simultaneously brilliant and catastrophically stupid. It's brilliant because pattern matching is actually incredibly useful for many legal tasks, like spotting relevant clauses in contracts, summarizing depositions, drafting first draft motions. However, it can also be catastrophically stupid because when it encounters a pattern that it hasn't seen before, it does not know how to say, I don't know. It just generates whatever pattern seems the most plausible. And this is an inherent failure in the way that the models were created originally. And that's also how you get the fake case citations that sound completely real. There's a whole discussion to be had about, like, why does AI hallucinate? I'll talk a little bit more about it later, but be that as it may. The analogy that I like is it's autocomplete on steroids. It's not HAL 9000. It's not going to lock you out of the pod bay doors because it thinks you're plotting against it yet. Your phone's autocomplete predicts the next word based on what you usually type, and it gets better at it as you use your phone more and more. AI does exactly the same thing. It's just much more sophisticated, and it has a lot more training data. But the fundamental mechanism, predict the next word based on patterns, and basically based on the fact that, with a bell curve, you're always going to fall somewhere, almost always fall somewhere in the peak of the bell curve, is the same. And I'm not trying to diminish what AI is capable of. Pattern matching at this scale is really very useful, but it's also not magic, so you have to understand the limitations. There's no reasoning, it's just pattern matching, and that can help you to know where AI will work well in highly structured tasks with clear patterns, and where it's going to fail in novel situations that require actual judgment or where there's not a lot of precedent to go on. And if you remember absolutely nothing else from this section, this is what I want you to remember. AI is going to make mistakes, and it is going to make those mistakes with confidence. A human being who doesn't know something most of the time is going to hedge. I think. I'm not sure, but something like that. If they're a salesperson, they might not. But AI doesn't do that. It is going to generate the most plausible sounding answer, whether it's correct or complete nonsense, and it will do it with equal confidence. And that's why verification is non-negotiable. So that's what AI is. I think I probably did spend about 3 minutes on it instead of 90 seconds, but be that as it may. Now let's talk about why March 2026 is different from 2023. And this still says February. I apologize. This is supposed to say March, but there we are. This is why I do this in the afternoons and the evenings. So why is February, March 2026 different than 2023? 3 years ago, if you came to me asking about AI for legal work, I would have actually asked what the hell you were doing in my house. But then I would have told you to wait. The tools aren't ready. They have some impressive demos, but they're really not good to go for production. That has changed. So let's talk about what's matured. First, accuracy has improved significantly. The models are better trained, the legal specific versions have more relevant data, and the error rates have dropped substantially. They have not dropped to zero, we'll get more to that in a minute, but they are noticeably better than they were in 2023. Second, we now have independent benchmarks. We have the VLAIR study from Val's AI, released in multiple iterations through 2025, and that's the first serious independent evaluation of legal AI tools. They tested Harvey, CoCounsel, Vincent AI, and several others against a baseline of actual human lawyers on real legal tasks. That makes it sound like we've also got extraterrestrial lawyers kicking around there somewhere, but, maybe in Roswell. The most recent study from October 2025 added Alexi, Counsel Stack, Midpage, and even ChatGPT. And really, it's hard to overstate the value and importance of this, because before this, we only had vendor claims. And they're going to tell you that everything's going to be fine, dandy, and fantabulous because they want your money. Now, we have third-party data that we can use to compare the claims against reality. Third, there's now legal-specific training. Tools like CoCounsel and Harvey aren't just generic AIs. They've been trained on legal texts, cases, and statutes, and been modified and coded to really focus on that as their subject of excellence. This does matter because they're much more likely to understand legal terminology as legal terminology and less likely to go completely off the rails. But, and this is the critical but, here's what has not changed. I still click too fast and scroll past the rest of my notes. Hallucination risk is still a big problem. The VLAIR studies found that even legal-specific tools still struggle with certain tasks. There is, depending on the tool and the prompt, or the task, there's still a 17 to 33% hallucination rate from these supposedly production-ready tools. They are better than generic AI like ChatGPT, but they are by no means perfect. If you think about a 33% hallucination rate, that means that 1 in 3 responses that provides a case citation or something like that is still made up. Verification remains mandatory. Every case citation, legal proposition, factual claim, you have to check it. It is non-negotiable. Anyone who tells you otherwise is setting you up for sanctions and frankly just cannot be trusted. Do not give them your money. AI is also still not a substitute for professional judgment. It can help you research faster, it can help you draft quicker, it can help you spot issues more efficiently, but it cannot replace your expertise in knowing what arguments will work, what the opposing counsel will say, and what the judge will find persuasive. That's still your job as an attorney. The key stat from the October 2025 VLAIR legal research study is that AI tools scored 74 to 78% on legal research tasks. Okay, great. That's a C, maybe a C plus. Until we think about the baseline that the lawyers set. They got 69%. So, certain AI tools are now capable of matching or even slightly exceeding human lawyers on certain defined legal research questions. But, this is important, the lawyers outperformed AI on 4 out of 10 question types. And where lawyers excelled, they did so by an average of 9 percentage points. The study thus concluded that AI provides significant support, but human expertise is still creating an edge when deeper context, complex multi-jurisdictional reviews, and judgment-based synthesis are required. So the message of Q1 2023 is that AI is now good enough to be useful. It is not good enough to be trusted blindly. That's the reality of 2026, at least the start of it. So those are the basics. AI is pattern matching that's gotten good enough to be useful, but not good enough to be trusted implicitly. Now let's talk about why you actually need to care about this, apart from, saving yourself some time each week. I say that before I move into why you should adopt AI. I want to just really hone in on 3 things that need to be internalized. Write these down if you're taking notes, because everything else in this presentation assumes that you understand, accept, and are on board with these 3 points. Number 1, outputs require verification. Every single time, every case citation, factual statement, legal proposition, no exceptions. I'm going to sound like a broken record saying this, but I cannot overstate the importance of this enough. I know it seems obvious after I briefly talked about hallucinations. We're going to talk about hallucinations more in a minute, but I have talked to lawyers who say things like, well, I verified the first few outputs and they were fine, so I just stopped checking. And if I had hair that was long enough for it to look gray, that's where I would be getting more and more of them. That's how you end up sanctioned. The cost of skipping verification is too high. Don't care if you think it saves you 20 or 30 minutes, because we're talking about your license, your reputation, your client's cases. Verify everything. And again, I'm, just recording this. If you don't, it's no skin off my back, but I am doing this because I genuinely want to help people succeed. So just take the extra time, accept that you're still saving a lot of time over what your previous ways of working would be, and take the time to do your due diligence. Number 2, legal specific does not mean error-free. Just talked about this again. There's a tendency to think, okay, if I used Harvey or CoCounsel or Lexis Plus, they are tools that were specifically built for legal work, so I don't need to worry about it. That's wrong. They are excellent tools. They're significantly better than generic AI for legal tasks, but they still make mistakes. The VLAIR benchmarks prove both that they are excellent and they are still, fallible. CoCounsel, which was built by Thomson Reuters using ChatGPT 4, and their entire legal database, and Thomson Reuters has a lot, still had technical issues and instances where it could not produce responses when VLAIR did their study. Harvey, which is used by top AM law firms, huge law firms, scored highest on most tasks, but still had gaps. These are the best tools available, but they are still imperfect. In the same way that there is no single tool that will be perfect for every job. At the same time, there's that, fun phrase about if all you have is a hammer, everything looks like a nail, but there are still some things you should not whack with a hammer. Primarily, starting with your loved ones. Okay, that might be a little bit dark and not make it into the final edit. Okay, number 3, your ethical obligations do not change because you used AI, and this is probably the most crucial one to internalize. Model Rule 1.1, competence still applies. 1.6, confidentiality, still applies. That one I'm going to really harp on here in a minute. Rule 3.3, candor to the tribunal, still applies. Using AI does not give you a free pass to malpractice. You can't go to a disciplinary hearing and say, oh, well, the AI told me this was a real case. The court will respond, I don't care because you didn't verify it, and now you're sanctioned. ABA Formal Opinion 512, which we'll get into in a little bit, makes this very explicit. Lawyers using AI must understand the tool's capabilities and limitations. They must verify their outputs, see number 1, protect client confidentiality, and ensure competent representation. Using AI creates additional obligations. It does not reduce your existing ones. And talk about just a quick real-world consequence. We had a Johnson versus Dunn, a large, well-regarded law firm, included hallucinated citation in a motion that they filed. The court emphasized that the attorney's signature meant responsibility for every word in the filing, regardless of who initially drafted it, whether it was or what tool was used. Could have been an AI, could have been a paralegal, doesn't matter. Could have been the the lawyer's 6-year-old daughter. It doesn't matter. Lawyer signed off. That means that they accept responsibility for every word in the filing. The firm avoided sanctions only because of their very thorough remedial response. They conducted a comprehensive docket review, an independent audit, and had full transparency with the court. Now that's the standard. Okay. Now we understand what AI is, what it can and can't do, and what your responsibilities are. Let's talk about why, after all this scaring, why you need to adopt it anyway. Okay. These are the real problems that AI is capable of solving. Not the marketing hype, not the overpromising, the real documented benefits. First one's document review. Thomson Reuters analyzed their data across thousands of law firms and calculated that AI is saving 266 million hours annually across the legal profession. That's million with an M, 266 million. That's not just a projection, that is the actual measured time savings. Now, you're not going to see all 266 million of those hours, but the point is that this is not theoretical. Firms are documenting real efficiency gains. Second is legal research. VLAIR study from October of 25 showed that AI tools score 74 to 78% on legal research tasks. That baseline, 69%. So AI is now matching or slightly exceeding human lawyers on defined legal research questions. Not all questions, but enough to be useful. Drafting. This is my personal favorite. Well, maybe that in client communications, but client communications are also a type of drafting. First drafts that used to take hours can now be done in minutes. And I don't mean good first drafts. I mean the kind of first draft that you get from a paralegal who's worked on this matter once or twice before. You can improve the quality by providing, samples and templates, but it's still valuable either way because even a mediocre first draft is better than a blank page that you've got to start working on from the beginning. And then finally, client communications. Status updates, appointment confirmations, routine correspondence, as well as some, client journey related things with the chatbots and things like that. All of this stuff can be largely automated. Not the substantive legal advice, obviously, but the administrative overhead. And the theme here, really, if you think about all four of these elements, is that you're going to see efficiency gains on repetitive work. AI is not here to replace your judgment, your client relationships, or your ability to read a room. But what it does do is give you back the time that you're currently spending on tasks that don't require those skills. And here's why doing nothing is no longer a viable strategy. There are a lot of conflicting numbers about exactly who is doing what. Again, I'm going to throw a lot of them at you. Don't anchor to any specific one number or metric. The overarching message is that the time to act is now. First number, 79% of legal professionals are using AI in some way. That's from the 2025 Clio Legal Trends report. If you're not using it, you are now increasingly in the minority, and that 79% is just going to increase. However, small firms are lagging. Only 20% have firm-wide adoption. So if you're a small firm, 5 million or so or under, thinking, I can wait, you're still in good company. Actually, if it's less than 50 lawyers, that's really anybody under about 40 or 50 million, but be that as it may. The problem is that 80% of legal professionals, regardless of their firm size, are expecting AI use to increase over the next year. So the window for strategic early adoption, is closing. Thomson Reuters is estimating that about $100,000 in additional billable value per attorney annually can be realized through AI implementations in time savings. That's not actual revenue, it's just capacity. Hours that you're currently spending on research and drafting that could be spent on higher value work, or, a radical thought here, taking time off, making it home before 9 p.m. for once. And then there's talent. If you're trying to recruit top associates away from a good law school, not away from a good law school, but from a good law school in 2026, they're going to expect that they're going to have modern tools to work with. If your pitch is, we do things the old-fashioned way, dust off the IBM Selectric, set that out, give everybody a secretary or four, and you're still going to be competing with firms that can offer a much better work-life balance simply through better technology. So the competitive pressure here is real. I'm not talking to you about being on the bleeding edge. That part of the adoption life cycle has passed. We'll talk about that in a minute. It's just about not being left behind. So, where are you on the adoption curve? We're not on the bleeding edge. We're not with the innovators. If you're familiar with Jeffrey Moore's innovation adoption curve, this is where we're talking, and this is what we're talking about right now. You've got your innovators, your early adopters, your early majority, late majority, and your laggards. Right now, you are solidly in the early majority. You're not a guinea pig. The innovators tested this stuff in 2023 when it was genuinely risky. They made a lot of mistakes. Some of them probably got hallucinated cases through the court at the time because people weren't really looking out for it. Be that as it may, the early adopters were deploying it in 2024, maybe early 25, when the tools were better but still immature. Now we're at the end of Q1 2026, and we're looking at proven technology with documented best practices and clear ROI data. Mid-sized firms are leading adoption at 39%. Small firms, only 20%. But here's the thing. Like I said in the last slide, 80% of all firms, regardless of size, are expecting to increase their AI use. So being early majority means that you're in what I would call the strategic sweet spot. We know the technology works, we understand the risks, and the competitive pressure is mounting. If you delay another year, you're moving from early majority to late majority. And late majority means you're playing catch up while your competitors are optimizing systems that they've been running for a year or two. So the underlying message here is you're not late, but your window to be early is closing. Act in 2026 and you're still being strategic. If you wait until 2027 or fie upon you 2028, you're just being reactive. This is a practice area breakdown from the 2025 Legal Industry Report. I just picked a sample of some of the firms that I most frequently work with. I'm sorry, I left off estate planning, mea culpa. But immigration is leading in personal use at 47%, but firm-wide adoption is only at 17%, which is really a telling gap, even more so. I mean, and you see this trend to some extent across all five of these examples, but the big gap in immigration is really the most telling because it tells you that individual lawyers and individual staff members are experimenting, but there hasn't been an institutionalization of use yet. Civil litigation has the best firm-wide adoption at 27%. Personal injury and family are around 20% each. Criminal law and trusts and estates. They didn't make it into the graph, but criminal law and estate planning are around 18%. The pattern across all these areas is that individual attorneys are using AI at a much higher rate than firm-wide adoption numbers would suggest, which tells you two things. One is that there is significant grassroots interest. Your associates are probably already using ChatGPT or some other publicly available AI, BBC neutrality rules, other AIs are available, whether you know about it or not. And two, firms are inherently slower to institutionalize than individuals are to adopt. This isn't particularly surprising. Most firms are using generic tools like ChatGPT combined with legal research platforms. They're not buying the expensive enterprise solutions. This isn't surprising, again, because if it's individual attorneys that are adopting it, or even if it's a sort of staggered adoption, it's easier to just say, okay, well, what have you already been doing? Let's keep working with that rather than, extremely expensive shiny object. They're using accessible tools and running controlled pilots before expanding. This approach is strategic and it's cautious. Nobody's betting the farm. You're just testing carefully, documenting your results, measuring your ROI, If you don't have your data, you can't expand strategically and then implementing gradually, which is exactly what you should do. But keep your data so you can measure your ROI and make your decisions based on that rather than, oh, this felt best. So let's talk about the actual economics rather than the vendor pitch version. Again, this is why it's so important to have your data. Costs. Tool subscriptions are going to range from $110 to $400 a month, depending on what you choose. We're talking training time of 10 to 20 hours initially for your team to get comfortable, then probably some ongoing learning, hour a week, eventually transitioning to an hour or two a month. Development of policies and procedures, probably 1 to 2 weeks of attorney time to create not only a proper AI use policy. I suppose if you want to be perverse about it, you could have ChatGPT or Claude or something write you an AI use policy, but that feels like, a bit of a bridge too far. Use it for the drafting and then have an attorney review it. But the benefits. You're going to see a time savings of 20 to 30% on specific tasks where AI is deployed, and I need to be clear about that. It's not across your entire practice. It's just on the tasks where you're actually using an AI. It's going to be reduced paralegal hours on routine work. It's going to be improved work product quality through consistency. That's a big one. Still need to review, but the consistency, especially if you provide the AI with good templates and examples to follow, can be much, much better than using human beings for some of the drafting and things like that. Typically, you're going to see a break-even hit around 3 to 6 months for small firms. After that, your ROI will improve with scale. More attorneys using it, more use cases deployed, better optimization of workflows, etc. One critical point that often gets lost: AI augments lawyers, AI augments paralegals. It does not replace them. You still need the attorney judgment. You still need the paralegal experience to be able to go over a draft and polish it before it goes to the attorney. AI is going to handle the pattern recognition, first draft generation. You and your staff are going to handle the strategy, the client relationships, and everything that requires actual understanding rather than just pattern matching. The economics work if you approach this as an efficiency tool rather than a replacement strategy. Because the second that you start thinking, oh, we can fire a paralegal because we have AI, you're setting yourself up for problems. A paralegal who knows your systems and knows your clients is worth far more than the tool subscription. And here's where we need to reframe the risk question, because most people think about it backwards. The question I'm most often asked by the skeptics in the room is, oh, what's my malpractice risk from using AI? And that's the wrong question. The right question is now, what's my malpractice risk from not staying current with available technology? Formal Opinion 512 from the ABA actually makes this explicit. Competence includes understanding AI benefits and risks. Comment 8 to Model Rule 1.1 has required technological competence since long before ChatGPT existed. This isn't new, it's just newly urgent. Think about it this way. Would you argue that you shouldn't use Westlaw because law books might be wrong? Of course not. Use the best available tools, and then you verify the results. It's the same thing, I made the joke a little bit earlier about dusting off the Selectric, but you're not going to avoid using word processors just because the words only appear on the screen and then who knows if they're actually going to be printed the same way. That's silly. AI is the same. The real malpractice use is using AI incompetently. Hallucinations, missed verifications, confidentiality breaches, those sort of things. But competent use, where you understand the tool's limitations, you verify the outputs, and then you maintain appropriate supervision, actually reduces your malpractice risk by improving your accuracy, your efficiency, and your consistency. Documented verification protocols protect you. If you can show a disciplinary committee that you had a policy, you followed it, you verified citations, and you supervised outputs, that's evidence of competent practice. Ignorance is not a defense. I didn't use AI because I didn't understand it, won't fly. I used AI competently with appropriate safeguards, will. Okay, state of play, again. Okay, I updated the first slide and then forgot that I put time binding in the whole thing. I apologize, Mr. Korzybski. As best we can establish, this is our current state of play in February and probably still in March 2026. Things change, but they don't change nearly that quickly, and all these studies are from 2025 anyway. A lot of different stats floating around, messaging is the same, time to act is now. Smokeball's report from 2025 showed that 53% of small firms and solo practitioners have adopted AI in some way. That's up from 27% in 2023, so it's nearly doubled in the last 2 years. Doesn't mean they're using it for everything, doesn't mean it's necessarily being used firm-wide in all applications, but 53% are using it in some context. Clio showed that 71% of solo firms are using AI in some capacity. A lot of this probably comes down to how you word the questions. But when you dig into what widely or universally means, which is to say a comprehensive deployment across the practice, you get 8% for solos and 4% for small firms. So, as best I can analyze, what's happening is a lot of experimentation, but very limited deep integration. People are testing, piloting, feeling it out, which is smart. But again, the trajectory is clear. 80+% are expecting to increase their use. You're not a laggard if you start now. You're in the mainstream, you're an early adopter, but delay another year and you're going to be playing catch up. You're not late, but you're also not early. The window for strategic adoption, where you can learn from others' mistakes but still gain a competitive advantage, is still open, but it's not going to stay open indefinitely. So, let's talk through ABA Formal Opinion 512. This was issued July 29th, 2024, which, July 29th is my uncle's birthday. That's fun. This is their comprehensive guidance on AI ethics that everyone was potentially waiting for, either with bated breath or slight fear. But let me walk you through the 6 core areas. Again, full disclaimer, I'm not an attorney. I've also had a drink in and out of hand for the last 15 slides, so this isn't legal advice. Anyway, first, competence, rule 1.1. You have to understand AI capabilities and limitations. You don't need to become a computer scientist, but you need to know what the tool can and cannot do. You need to understand hallucination risk. You need to maintain your technological competence as the tools evolve. Second, confidentiality. Rule 1.6. Client information must be protected. If you are using a tool that trains on your inputs, that's a confidentiality problem. If you're uploading client documents to a generic chatbot like ChatGPT that doesn't have enterprise data protection, that's a confidentiality problem. Check and double check the data handling policies before you use anything. Third, communication. Rule 1.4. You must disclose AI use when it's material to the representation. Now, material is a word that's doing a lot of heavy lifting there. If you used AI to brainstorm internally, it's probably not material. Again, not an attorney, this is not legal advice, but it's probably not. If you used AI to draft the brief that's going to the court, probably is material. When in doubt, err on the side of caution, as Dr. Asfor always told me, and disclose. Fourth, candor. Rules 3.1 and 3.3. No fake citations. Every case must exist, must say what you claim it says. That's the real bugaboo, because even if ChatGPT or Claude or Harvey or CoCounsel comes up with the correct citation, you still have to go through. You can't just verify, oh, that case exists. You have to make sure that that case exists, says what you or the AI claims it says, and that it's still good law. This is not new, as you've always had to verify your research, and AI doesn't change that obligation. It just makes it more urgent because AI will confidently cite cases that either don't exist or aren't actually relevant to your case. Fifth, supervision. Rules 5.1 and 5.3. You have to supervise staff who use AI. You must supervise the AI itself. If a paralegal is using CoCounsel to draft research memos, you still need to review those memos. You can't just say the AI did it and wash your hands. And then sixth, fees. Rule 1.5. You have to bill for the hours delivered, not the hours spent. If AI cut your research time from 10 hours to 3 hours, you can't bill the client for 10 hours. Again, not an attorney. This is not legal advice, but the ABA is pretty damn clear on this. Efficiency gains should benefit the clients, not just pad your bills. None of these are new obligations. They're just existing rules that have been applied to new technology, which means the standards are already established. We just have to reframe them in an AI context, which we've kind of just done. Here's the complication, though. Opinion 512 is just model guidance. It's not actually binding. Your state bar is then going to interpret and enforce ethical rules, and states can and do vary. That's part of the whole fun of our federal system. So you have 3 places to check. First one is your state bar website. Look for ethics opinions, AI guidance, formal advisory opinions, etc. Florida Bar has an opinion out, 24-1, that addresses the use of AI chatbots and advertising rules. Pennsylvania Joint Opinion 2024-200 covers conflicts and confidentiality. Texas has issued guidance. Your state probably has as well. If they haven't, they're probably going to do so sometime this year. 2, don't you hate when you get it, like you're about to get a sneeze and then it just kind of goes away again? It might come back in a moment, so watch this space. Your state Supreme Court. Some states have issued orders, rules, or technology standards. Check your court website. 3, local court rulings. Some federal and state courts have specific AI disclosure requirements. The Northern District of Texas, for example, requires certification that AI-generated content has been verified. Other courts are following suit, as one usually does when you recognize a good idea. Again, benefits of the federal system. Document your compliance when you create your AI policy. Cite the relevant ABA opinion, 512. Note your state-specific guidance and reference any local court rulings. If you're ever challenged, you want to be able to show that you did your research about the requirements and built your policy around them, rather than just, winging it or dithering and faffing a little bit. So, where does that leave us in determining our position and ability to wade into this new and relatively unexplored world? Well, I've developed a 3-layer framework for risk management as you think about implementing AI in your law firm. Layer 1 is tool selection. There are legal-specific tools like CoCounsel and Harvey versus generic tools like ChatGPT and Claude. Review your data handling policies. Not your data handling policies, the data handling policies of the tools. Does the tool train on your inputs? If yes, that's a confidentiality problem. Check your vendor security standards. They should have SOC 2 Type 2 certification. That's the baseline that you're going to be looking for. If a vendor can't produce that, you probably shouldn't be using them for client work. A pinky promise that it's not going to go outside their servers doesn't count. Layer 2, consider your use case. Internal work only or client-facing. Drafting assistance versus final work product. Supervised versus unsupervised. These risk levels stack. Internal brainstorming with generic AI is inherently low risk. Client-facing work product with an unsupervised AI? If you do that, I'm going to come whack you with a naughty stick. The risk assessment changes based on what you're using it for. And then layer 3 is verification. And I know I've harped on this already. I'm going to keep harping on it. Citation checking is mandatory for any legal output. Substance review for accuracy and relevance. Client disclosure, when AI materially affects their representation. This layer applies regardless of tool choice or use case. Everything has to get verified. Stack these layers appropriately. A low-risk use case with a legal-specific tool and comprehensive verification, it's an acceptable risk profile. If you've got a high-risk use case using a generic tool with minimal verification, that's how you end up getting sanctioned. And the goal for this is to prevent you from getting sanctioned. So don't do that. Now, said I was going to talk more about hallucinations in detail. Here's where we're going to do it, because this is a big one. Definition first. A hallucination is when AI generates false information that it presents as factual. Most commonly, this will show up as fake case citations. The AI is going to generate a case name that sounds completely plausible, complete with case numbers, and potentially even accurate judicial names, but the case doesn't exist. The scale of the problem, an internet person named Damien Charlotin maintains a database tracking AI hallucination cases. When I built this presentation, there were 912 documented cases where hallucinated content had appeared in court filings. 324 had been in U.S. courts, either federal, state, or tribal. 128 lawyers had already been sanctioned. 2 judges had even been caught using hallucinated citations. In August 2025, just 6, probably now 7 months ago, 3 separate federal courts sanctioned lawyers in a 2-week period. So this is stuff that's happening up to the minute. VLAIR data shows that even legal-specific tools that are specifically designed for legal work, trained on legal databases, still have those hallucination rates that we talked about, between 17 and 33% in certain contexts. These are the best tools available, and they're still generating false citations up to 1/3 of the time. So the bottom line is, assume every citation is wrong until you verify it. Not probably wrong, not might be wrong, assume it's fake. Open the case, and don't just open the case, read the relevant section, confirm it says what the AI claims it says, use Westlaw or Lexis to verify the case exists and is still good law, shepardize it, key cite it, document your verification. In your file, note, verified via Westlaw on what date. If you're ever challenged, you can prove that you did your job. Never skip this step to meet a deadline. File for an extension. Explain to the client that verification takes time. I don't care. Whatever you do, don't submit unverified AI output to a court. I'll give you 3 examples that should hopefully further reinforce the point that I have been harping on, clubbing on like a little harp seal. The MyPillow case, July 2025. Mike Lindell's lawyers, 2 of them, submitted a brief in a defamation case. It had multiple hallucinated citations. The judge sanctioned both attorneys $3,000 each, and the judge's language is actually worth noting, stating that this was the least severe sanction adequate to deter and punish. And frankly, I think she was holding back. $3,000 is, I mean, it's not insignificant, but it's still pretty minor. Second one, Gauthier versus Goodyear, 2024. The plaintiff's lawyer used Claude without ever verifying the output, had 2 non-existent cases and multiple fabricated quotations. They only got a $2,000 fine, plus a mandatory CLE on using AI in legal practice. The lawyer admitted in a show cause hearing that he never verified the citations, as just bone idleness and professional negligence. Then third, BYO Planet or Bioplanet, either way, in the Southern District of Florida, also in 2025. The attorney used AI-generated hallucinations across 8 different matters. 8. Court dismissed all 4 federal cases without prejudice, which is kind, and referred the lawyer to the state bar. This was not a one-time mistake. 8 different matters. It was a systematic failure. And then actually, here's a 4th one, and it's an interesting one. Johnson versus Dunn in the Northern District of Alabama, also July of 2025. It's a large, well-regarded firm, and they included only 1 hallucinated citation in the motion. I think I've talked about this one already. They did get caught, but they didn't get sanctioned. And they didn't get sanctioned because of their response. They immediately withdrew the problematic filing, conducted a comprehensive docket review of all their cases in that court, engaged another law firm to independently audit their filings, found no other instances, and were completely transparent with the court. And the lesson that we can take from Johnson versus Dunn is that even good firms can make mistakes, but responsible response matters. If you catch an error, you acknowledge it, you fix it, you figure out how it happened, and you prevent recurrence. The court should give you credit for that. And one more fun little twist. Noland versus Land of the Free in the California Court of Appeals, September of last year. The appellate's brief had fake citations. Appellant's brief. The court sanctioned the lawyer $10,000, which is, I think, a little bit more appropriate. But the court also declined to award attorney's fees to opposing counsel. Why? Because the opposing counsel didn't catch the fake citations. They didn't report it to the court. They only became aware when the court issued its order to show cause. The implication that you get here is that you do have a duty to spot obvious hallucinations in your opponent's briefs. That's what she said. We don't know how far that one's going to go, but it is something to keep an eye on. Okie dokie. So, practical compliance checklist. Before you use any AI tool for client work, go ahead and complete this checklist. Number 1, check the data handling policy. Does this tool train on your inputs? If yes, do not use it for confidential client information. Find out before you upload anything sensitive, anything with personally identifiable information, PII. 2, confirm client information won't be used to train the model. Some tools offer enterprise versions with data protection guarantees. Make sure that you're using the right version. 3, verify tool documentation and security standards. You're looking for SOC 2 Type 2 certification. You're looking to hear about what their data encryption tools are. Where are the servers located? Who has access? You're not being paranoid or prying and asking these questions. This is just doing your due diligence in the modern world. 4, create usage guidelines for your team. Who's allowed to use what? For what purposes? What approval is required? Do not allow improvisation because that's how you get sanctioned. 5, establish a verification protocol. Who's responsible for checking AI outputs? What's the process? How is it documented? Make this one overly explicit. There should be no opportunity or options for anybody to have ambiguity on that front. It's the same thing as, when you go get CPR training. You have to explicitly tell somebody, oh, you go call the ambulance, because if you just shout, oh, someone call 911, nobody's going to do it because they'll all assume someone else has done it. Same thing. 6, Document AI use in Matter files. Note which tool was used, when, for what purpose, who verified the output. If you're ever challenged, you want to be able to reconstruct your process, even if it's a slightly embarrassing or painful one to do. And this isn't bureaucracy for bureaucracy's sake, even though it can kind of feel like it. We're really here to do liability protection. If you can demonstrate reasonable care, we had a policy, we followed it, we verified our outputs, documented our process, etc., that's evidence of competent practice. It's not going to guarantee that you're never going to make a mistake, but it will show that you tried to do things correctly. Okay, risk spectrum. Think of this as a pyramid, even though I didn't build it as a pyramid because I'm not a graphic designer. I'm a consultant and slightly crazy person. Highest risk is any unsupervised client work. AI generates an output that goes directly to the clients without any review. Don't do this. I don't care how good the tool is. Just don't do this. It'd be like getting on an airplane, pushing autopilot and putting in your destination and just saying, well, that's job done. We don't need a pilot. Would you get on that kind of an airplane? I don't think so. I wouldn't. Hell, I wouldn't even get on a train that did that. And trains, just they don't go up and down, and they've got tracks that they follow. And I still wouldn't get on a train that had just a computer driving it. Anyway, medium risk, client-facing, supervised applications. You have an AI that assists, but an attorney extensively reviews everything before it goes to the client. This works with proper protocols, and we will discuss several applications in this category. Then we've got low, medium, and low risk. Low, medium risk is going to be things like administrative work, client comms, marketing content. A human being reviews it. In the case of the marketing content, an attorney reviews it, but the stakes are much lower because you're not giving legal advice, you're confirming appointments, generating leads, etc. And the lowest risk, things for internal operations, brainstorming, research summaries, documentation, policies and procedures, etc. You're the only audience. If the AI screws up, functionally it stays internal. We're going to focus on lowest and low medium risk applications first, then we'll tackle supervised client-facing work with appropriate warnings and verification requirements. Let's get started. First application, and we're not quite an hour in, so we're not doing great on time, but we're still doing better than the last couple of run-throughs I've done. First application, legal research summarization. This is the lowest risk, and this is where I recommend everyone start. What it is, you're just summarizing cases and statutes that you've already found through traditional research. AI isn't finding the law, you are. It's just helping you process what you found. There are some tools that work really well for this. CoCounsel is, from everything I've been able to see, quite excellent. They have basic tier at $110 a month and full access at $400. Lexis Plus AI integrates directly with the LexisNexis database. And honestly, the generic AI is going to work pretty well for this as well. ChatGPT, Claude, Gemini. So this is, I don't know whether it's Gemini or Gemini. It's probably Gemini. But every time I see that name now, I think about the fact that the space capsule program was, now everybody calls it Gemini, but when it was actually running, it was pronounced Gemini, and everybody seems to have forgotten that. Not to completely digress, but whatever you prefer. The workflow is straightforward. First, do your traditional research, use Westlaw, Lexis to find the relevant cases. You're not trusting AI to find the law, you're doing that part yourself. Then what you do is you feed the case text to AI. Copy, paste, upload the PDF, whatever's most comfortable for you, and then request a summary focusing on holdings, reasoning, or how the case distinguishes from your facts. Then fourth, you review the summary for accuracy. You're going to read the case anyway, you're just reading the summary first to orient yourself. Saves you time because you know kind of what you're looking for to start with. And then fifth, use the summary as a starting point for deeper analysis. But the time savings are significant. Instead of reading 10 cases fully blind, you read the AI-generated summaries first, identify the 3 most relevant cases, and deep dive into those. That's a 40 to 60% reduction in initial review time. A prompt you can use, just as an example, is summarize this case, uploaded, focusing on key holdings, court's reasoning, how it distinguishes from these facts, and put in, describe your client's situation, but don't include any PII, and fourth, any limiting language or qualifications in the option. Risk mitigation here is that you're verifying everything anyway because you're checking the original cases. The AI can't really lie to you about what a case says if you're going to read it for yourself. The worst thing that happens is you get a bad summary and waste time reading the full case, which you were going to do anyway. Application number 2, case strategy brainstorming. This is another very much Lowest risk application because nothing actually leaves your office. Provide an anonymized fact pattern, remove the client names, identifying details, anything confidential like that. Then ask the AI, what arguments could I make? What will opposing counsel say? What weaknesses do you see in my position? The value that you get here is just a fresh perspective, not because the AI is smarter, it's not, but because it's not anchored by your initial framing, your initial Overton window. Sometimes that algorithmic perspective is going to spot issues that you're too close to the matter to see effectively. I'll give you an example. Let's say you represent a defendant in a breach of contract case. Plaintiff claims anticipatory repudiation based on an email where your client said, we might not be able to perform. You ask the AI, what defenses should I consider? The AI might suggest ambiguity in the language. Might not is not an unequivocal refusal. Lack of certainty required for anticipatory repudiation. Potential waiver by the client, continuing performance after receiving the email. Possibility that the statement was conditional rather than absolute. Now, you would have probably thought of these anyway if you're competent, but maybe AI orders them differently than you would have. Maybe it emphasizes one that you would otherwise treat as secondary. Maybe it flags something that you were going to skip that actually deserves attention. The key point here is that you evaluate the ideas that it gives you. You keep the good ones, throw out the bad ones. Your professional judgment is still exercised and stays intact. AI is just another voice in the brainstorming session that costs a lot less than enough counsel. Because this is pure internal brainstorming, nothing is going to the client or the court, there's no verification burden. If AI suggests a terrible idea, you just don't use it and there's no harm done. Application number 3, internal documentation, training materials, that sort of thing. Another fantastically low risk application because nothing leaves the firm. Some examples: intake checklists, conflict check protocols, file management procedures, new employee onboarding guides, software tutorials, anything that's internal, doesn't involve client advice or court filings. It's all just sort of operational documents. Generic AI works fine here. You don't need co-counsel for this. ChatGPT or Claude's perfectly adequate, particularly, again, if you provide it with some guidelines and templates for emulation of what you've already got. But time savings are dramatic. You can achieve 70+% reduction in your documentation creation time. Instead of spending an afternoon writing an intake checklist from scratch, you spend 20 minutes reviewing and editing an AI-generated draft. The AI asks the right questions, you provide firm-specific answers, you've got a draft. You review it for accuracy and relevance to your specific practice, make adjustments, job's a good one. The human review ensures accuracy and firm-specific customization, but you're not drafting from zero, you're editing from 80% done. Application number 4. We're moving into low-medium risk territory now. So that's going to be, we're going to start with client intake screening. Okay, brief jump cut to get a proper refill on the bevy and take care of Mini Lensler for a moment. Anyway, moving into low-medium risk territory now, we're going to talk about client intake screening. AI is going to be able to screen potential clients, flag promising cases, and automate initial questionnaires. There are some tools that actually work really well. Lawmatics has AI lead scoring built in. I also like Lawmatics because once you figure out its reporting, it's actually really got some pretty good reporting capabilities, unlike Filevine. Custom chatbots can collect information. Clio Duo integrates with the rest of the Clio ecosystem. Managed being a better tool option than Grow, but beside the point. The workflow here. You have an automated questionnaire that gathers facts from potential clients. AI scores them based on your criteria. Case value indicators, jurisdiction, opposing party solvency, statute of limitations, whatever matters for your practice. High potential cases get flagged for attorney review. Critical distinction that needs to be made here: the attorney still has to make the final decision on representation. AI doesn't have the ability to accept or reject clients. It just prioritizes your review queue. That rhymes. That's fun. The most important thing for risk management, this is important for risk management and for ethical compliance, but the ROI is significant. Firms that have implemented client intake screening with AI have reported capturing 15 to 25% more qualified leads through faster response times and systematic screening. When a potential client fills out a form at 11 p.m., they get an immediate automated response with next steps. Your competitors who rely on manual intake might not respond until the next business day. By then, your client has moved on. There's whole rule of thumb about the fact that if you are able to respond within the first 5 minutes to prospective new clients, your chances of converting them to become clients increases by like 50% or something, versus if you get to them within the first hour. And if you get to them within the first hour, your chances are still good, comparatively speaking, but those first 5 minutes really, really matter. However, there is a risk consideration. When clients see an automated questionnaire and response, there's still, therefore, some exposure because it's client-facing. As long as you're clear that there's no attorney-client relationship that is created until after a human review, and as long as you're not giving legal advice through the automated system, you should be in good shape. But just want to, call that out as a potential for, risk consideration. Alrighty. Application number 5, administrative document drafting. Things like engagement letters, legal services agreements, client status updates, appointment confirmations. Again, the time savings are dramatic, just like the internal documentation drafting. Creating an engagement letter can drop from 15 minutes to 3. That's an 80% savings. Status updates, 10 minutes to 2. Generally speaking, we're looking at, about an 75 to 80% time savings on administrative document drafting. Appointment confirmations can be fully automated because, frankly, it's very formulaic. Even when you're doing them manually, it should just be from a template and you fill in the correct boxes. As far as tools, Clio Duo, again, integrates with your calendar and matter data so it can pull information automatically. Generic AI will work well for templates. There's a program out there called Spellbook that will also work well for contract-based engagement letters. The critical distinction to make here is that these are not legal documents, they're business documents. And that's why they're lower risk. An engagement letter that explains the scope of representation and the billing terms is important, of course, but it's not a legal analysis. A status update that tells the client what happened at the hearing. That's a communication. It's not advice, it's just a summary. You still need human review for accuracy and for personalization. You can't just auto-generate and auto-send, but the first draft takes minutes instead of starting from scratch each time. Application number 6, marketing and content creation. These are things like blog posts, newsletters, social media, website copy. Generic AI is going to be really the what you need for this. ChatGPT, Claude, whatever you prefer. You don't need to pay for any expensive legal specific tools. Again, your time savings can be 60 to 80% on first drafts. You're still going to need to edit for voice, accuracy, firm specific positioning, etc., but you're editing, not writing from zero. Compliance considerations. First, review for accuracy. Do not make false claims about results or capabilities. Second, avoid creating attorney-client relationships. These are really the same compliance considerations that you have to, consider when you're creating marketing copy, whether you're using a vendor, doing it yourself, or otherwise. Third, follow state advertising rules. Again, same kind of thing. Some states do have specific requirements about disclaimers, claims, and testimonials, but within those guardrails, AI is going to be excellent for content marketing. It can create blog post outlines, draft social media content, write newsletter summaries. You have to review, you have to adjust for your voice. As I've said with a couple of other things, if you can provide templates and writing samples and everything else like that, it will be a much easier adjustment because some programs do a much better job than others at kind of emulating provided writing samples. But either way, adjust for your voice, verify accuracy, and then publish. Again, it's going to save you a lot of time, especially on the drafting process. Quick note on practice management integration before we move into client-facing, more larger client-facing applications. Clio Duo is built into Clio Manage. MyCase IQ built into MyCase. If you're in either of these, if you're in MyCase, please consider moving on. I said I wasn't going to plug any softwares. I am going to dunk on a couple of them. MyCase's reporting sucks. Be that as it may. MyCase IQ is built into MyCase. If you're in either of those systems, your data's already in there. There's no export needed. You have some integrated workflows. The disadvantage is that you're tied to that practice management system. Functionality may be somewhat more limited compared to standalone tools. The decision tree here is simple. If you're already using Clio or MyCase, try their AI first. If it's something that you like, great. It is convenient, the integration is valuable, but if you find that you need more advanced features or flexibility, you can consider standalone tools like CoCounsel or Harvey. It also makes it a little bit easier to then leave MyCase when you decide that you do want actually, decent reporting and the ability to export your data efficiently. Not that I have a bugaboo about any of that. I don't have any particular truck with Clio. Now we're going to move into the medium risk territory. These are going to be the client-facing supervised applications. These are going to be applications where we're creating work product that the clients will see. They will require extensive attorney review. They must, or usually must be, disclosed to clients. The ethical stakes, therefore, are higher. But they are still worth doing if and only if you supervise them properly. That means comprehensive verification protocols. That means attorney review of everything. That means client disclosure when appropriate and required by your jurisdiction. The following applications fall into this category, and each comes with detailed verification requirements as we touch on them. Don't skip the verification steps. Don't get lazy. Don't think the AI is usually right, so I'll just spot check. Every output needs to be verified every time. I know you're tired of me telling you this, but I cannot overstate the criticality of it. Alrighty, application number 7, contract review and analysis. There's a bunch of different tools out there. Spellbook integrates directly with Microsoft Word. It's about $40 a month, which works well for small to medium volume. If you're working with some higher volume contract review, particularly if you're in something like estate planning or business law, Diligent is going to be a better option. You've got CoCounsel. If you're at an enterprise level, look into something more like Harvey. VLAIR benchmarks showed that Harvey had a 94.8% accuracy on document Q&A tasks, which is probably better than you're going to get from most human beings. These are good tools. Workflow, however, is critical. First, upload the contract. If you're using a generic tool rather than a legal specific one, redact client identifying information first. Second, request an analysis. Ask for unusual terms, unfavorable clauses, missing protections, deviations from your standard language, anything else that might raise a yellow or red flag under other circumstances. Third, this is non-negotiable. Review every issue that the AI identifies. Verify it's actually a problem. Verify that you understand the context. Fourth, draft your attorney analysis. Don't just forward the AI output to the client. I'm going to say that again. Don't just forward the output to the client. And then fifth, deliver with appropriate disclosure. Time savings you're going to see probably about 50% on the initial review, but you have to understand what that means. It's just the initial review. You're still reviewing the contract. You're just reviewing it with AI assistance, flagging potential issues. You're not skipping the review. You're just making it more efficient. Your verification checklist is going to contain or sound something like this. Did the AI miss any critical issues? Which you should notice because you still reviewed the whole thing. Is everything it flagged actually a problem, or are some false positives? Is the AI's characterization of the issues accurate? Have I confirmed my own understanding for each flagged clause? Then you're good to proceed. Application 8, discovery document analysis. The problem here is that discovery frequently working with tens of thousands of pages of documents and reviewing them manually is a nightmare for whoever is unfortunate enough to get landed with it, which is usually an unfortunate paralegal. The old approach was either a lot of billable hours or critical evidence being missed. AI provides a solution with initial categorization and relevance scoring. CoCounsel Relativity 1 for mass e-discovery, Diligent for contract-focused discovery are all intended to help with these. You're going to see probably 60 to 70% time savings on a first-pass review, but you still need to do probably paralegal and attorney review of the documents that AI flags as important. And you also want to be sampling the documents that AI says aren't important to verify that it didn't miss anything. And I know that I'm kind of contradicting myself a little bit here in saying that for this, you're going to sample the documents that it says aren't important rather than go through each document that it says aren't important, but we're talking about tens of thousands of pages. If in 10,000 pages of documents, you sample 200 to 500 and you find no errors, probably safe to proceed. Again, not legal advice, not your lawyer, etc., etc. The converse is also true. If it flags a whole bunch of items as important and you find that 70% of them aren't, you're back to square one. But security is critical here. Discovery documents are confidential. Choose tools that won't train on your data. Verify their data handling policies before uploading thousands of pages of client documents. The workflow that you're going to want to use. AI is going to categorize the documents, score them for relevance to your case. It's going to flag high priority documents for your review. The paralegal and the attorney are going to review the flagged documents. They're going to sample the non-flagged documents to verify the AI's judgment. And then the attorney is going to pull the critical documents for closer analysis. Application number 9, legal drafting. Got motions, briefs, demand letters, that sort of thing. If you're in immigration, everything related to almost every USCIS case that you send in, you can, to some extent, draft with AI. This is the highest risk supervised application that we're going to discuss. And the workflow here is absolutely non-negotiable. First, you're going to want to provide a detailed fact pattern with legal issues and jurisdiction. And you need to be specific about this. You can't just say, oh, write me a motion. You have to say, I need a motion to dismiss for failure to state a claim under Rule 12B, parentheses 6, in the Pennsylvania Federal Court for a breach of contract case. Second, generate the draft. Third, and I cannot emphasize this enough, verify every single case citation. Maybe that should be the, every time I say verify everything, is take another drink. Open every case, read the relevant section, confirm it exists, confirm it says what AI claims, confirm it's still good law, use Shepard's, use Keysight, etc., etc., etc. Fourth, review the legal arguments for soundness. Are they actually good arguments, or did AI string together plausible sounding language that won't actually hold up under scrutiny? And then fifth, revise substantially. Don't just edit, revise sections, add analysis, remove weak arguments, remove M-dashes, make it yours. Make it sound like you. Sixth, treat it as a first draft, not a final product. You should still be investing significant time in turning the AI draft into something that you would actually file. Time savings, therefore, is only going to be 30 to 40%. It's less than the other applications because, yeah, the verification is very intensive. But out of a 40-hour work week, 30 to 40% is still 16 hours at the high end, 12 hours at the low end. So it's still meaningful. I mean, that's 2 days worth of work. Billing consideration. ABA Opinion 512 says you can't bill full price for AI drafted work if the time savings are substantial. Now, they don't say statistically significant or anything like that, so there's probably a little bit of fungibility there. But if it used to take you 10 hours and now it takes you 6, bill for 6 hours or bill a flat fee based on the value delivered, but don't bill for time that you didn't spend. Again, not legal advice, not your attorney, etc., etc. That's got to be our other drinking phrase. Cheers. Okie dokie. Gonna beat this horse one more time because of how important it is. Hallucination is the biggest problem with AI applications. There are 912 cases in the database the last time I checked. 324 in US courts, 128 lawyers sanctioned. God knows how many others that somehow got away with it. Recent examples I mentioned earlier, most of these folks I still think got off pretty easy. $3,000 in fines per attorney for the MyPillow case. Gautier versus Goodyear, $2,000 plus a CLE. BioPlanet or Bring Your Own Planet, whatever it's a silly name. 8 matters were dismissed. That one stings. Johnson versus Dunn, they managed to avoid sanctions because they responded responsibly. They were completely transparent with the court, and thus the court declined to sanction them. The lesson here is if you make a mistake, and you probably will, at some point respond responsibly. Don't try to hide it. Don't try to minimize it. Don't try to shuffle it under the carpet or the table or whatever. Acknowledge it, fix it, figure out how it happened, and prevent recurrence. Inshallah, the courts will give credit for that. Final twist with Noland, as we talked about, opposing counsel was sanctioned as well for failing to detect the opponent's hallucinations. That's kind of a new wrinkle because it suggests that you may well have a duty, again, not legal advice, to spot obvious fakes in the opponent's briefs. That's what she said. We don't know how far that will extend, but it is worth noting. Mitigation strategies, one more time. Assume every citation is fake until proven real. Manual verification. Open the case, read it, or, at least have a paralegal open the case, read it, and give you a gut check, and then still verify again, but you can do it a little faster. Use your legal research platforms to confirm. Document your verification process, and never skip this step to save time. Okay. Horse, well beaten. Tool selection decision tree. Let's move into the really practical stuff here. Budget. If you have $0 to $110 to spend a month on AI exploration, use generic AI plus whatever research platform you already subscribe to. If you can spare a little more, look into CoCounsel. They have tiered pricing in the $100 to $400 range. If you've got, if you're comfortable burning a little bit more cash, you can look at Harvey for Enterprise or Lexis Plus AI for full-featured research. Practice area-wise, if you're primarily doing litigation, family law maybe, look at CoCounsel or Lexis Plus AI for its research capabilities. If you're transactional, Spellbook for contract work. If you're specific to estate planning, you could also look into Gavel, which I don't know if it really counts as AI, but it is a fantastic tool. If you're mixed practice, CoCounsel's got a little more versatility than most of the other things that you're looking for. As far as risk tolerance, if you have a high risk tolerance, a low risk tolerance, meaning you're very conservative, stick with the legal specific tools only. If you have a more medium risk tolerance, you can use the generic AIs for low risk applications and legal specific for client work. And if you have a high risk tolerance, meaning you're more comfortable experimenting, pilot everything with generic tools first, verify, and then upgrade later. From an integration perspective, if you have Clio or MyCase, try their built-in AI first because it's convenient, but if you need standalone tools with more capabilities, look into CoCounsel, Spellbook, those sort of things. If, from a firm size perspective, if you're a solo practitioner, start with generic AI to control your budget because it can balloon quite quickly. If you've got 2 to 5 attorneys, I'd still recommend kind of starting with generic AI, maybe look into 1 or 2 specific tools based on your practice area and use cases. If you're at more the 6 to 10 attorney level, get into the, high 7 figures or low 8 figures in revenue, you should probably look into some legal specific tools as they're probably justified by the volume of work you're doing at that point. I also recommend a phased implementation approach so that you can reduce risk. In phase 1, first couple of months, really just work internally. Do brainstorming, research summaries, internal documentation, but don't do anything that's got client exposure. Use this phase as a way to build confidence, develop your verification habits, and understand what the tools can and can't do. Phase 2 are going to be your 3rd and 4th months. Look into administrative applications, client comms, marketing, intake screening, the low-risk client-facing work. Make sure that human beings are reviewing everything. You're testing client-facing applications, but with low stakes. After each of these phases, conduct a thorough decomp, a thorough review to make sure that everything kind of actualized in the way that you expected it to. Realized how dark it had gotten, so I went and turned on the light. Another jump cut. Okay, phase 3 is going to be months 5 and 6. Supervised client work, things like contract review, research assistance, drafting with extensive verification. This is where your value is really going to accelerate, but it is also where your risk is highest. Don't rush into this phase. I know it says months 5 to 6 on here. If it's month 8 to 9, month 14, that's okay. Make sure phase 1 and phase 2 went well first and that you've plugged any holes, closed any gaps that you notice in those first 2 implementation phases. And then phase 4, tentatively month 7 and beyond, but only when you really feel comfortable with phases 1, 2, and 3, evaluate and expand. Look at your results. What worked? What did you learn? What went wrong? Again, make sure you have your data because this needs to be all based on actual data rather than hunches. Decide whether to expand, how to expand, to additional use cases, whether you want to invest in premium tools, and how you're going to increase deployment across your firm. This phased approach is going to prevent the most common mistake, which is trying to do everything at once, be all things to all people, etc., which leads to you getting overwhelmed, which leads to you making mistakes, and eventually abandoning the whole project as a bad job, and then you turn into a Luddite and start throwing shoes into weaving machines. That's an obscure reference. Okay, here's your 90-day implementation plan. We're 3/4 of the way through, and 3/4 of an hour, or 1.5 hours in. This is, again, tentatively a 90-day plan. Some firms may need 120 or 180 days. That's fine. Better slow and right than fast and sanctioned. Month 1, lay the foundation. For the first couple of weeks, you really just need to be developing policy, conducting research, etc. Weeks 3 and 4, you're going to train your staff and select a pilot application. Actually, strike that and reverse it. You're going to select a pilot application and then make sure that you're training the staff on that application. But you're not doing any client work. The entire first month should just be preparation for what is next to come. Month 2 is going to be your controlled pilot. Execute the pilot application that you selected. Track results meticulously. Learn to love your data. And then adjust the workflow as you learn what works and what doesn't. But document everything. Month 3, this is when, depending on the results of month 2, you conduct your measured expansion. If the pilot was successful, roll it out firm-wide. Continue quality checks. Do a comprehensive evaluation at the end of month 3 to decide what comes next to make sure that everybody's on board and aligned with the way that the execution is planned. Acknowledge up front that this is going to stretch. If you're a solo practitioner juggling client work, month 1 might take 6 weeks instead of 4, but that's okay. The timeline is a framework. It is not a straitjacket. So, go into a little more detail. Month 1 goal here is just to create the framework before you even touch the tools. Weeks 1 and 2, policy development. 3 and 4, pilot selection and training. The output of month 1 should be 3 things. 1, an approved AI use policy that everyone has read and agreed to follow. Disagree and commit really doesn't work here. I'm a big fan of disagree and commit. There's a Wikipedia article about it. Jeff Bezos came up with it, which, okay, one of the better things he's come up with. I still can't believe that Amazon was originally just a bookstore. Sidebar. But everyone create the policy, be prescriptive with it, and make sure that everybody has read and agreed to follow it. 2, train your team that understands what AI is, what it can do, what the ethical obligations are, and what your policy requires. Heck, if you've been enjoying this video, fantastic, thank you. Sit them down and have them watch this as a starter. Maybe do it at 5 o'clock on a Friday and bring a couple of bottles of wine so you guys can drink along with me. But either way, 3 is select your pilot application with identified participants and define success metrics. When you think about identifying participants, pick people, don't just pick the most technologically savvy folks in your firm, because they will find it easier than everyone else. Try and pick a bit of a cross-section of not just individuals who are going to be able to get in and play with the new technology. You'll want at least one of those people. But also pick somebody who might be a little bit more resistant to change, because they're going to be the ones that really identify the implementation pain points, rather than just say, oh, well, this is just part of, doing a new technology and then creating a workaround, which is what you'll get from the digital natives. Anyway, the temptation is to skip this month and just start using tools, but I have to encourage you to resist that temptation. Every firm that I have seen that skipped the policy and training phase has ended up with enormous problems, either inconsistent usage, mistakes being made, confusion about responsibilities. Clarity is absolutely everything. And as long as you can provide that clarity, you should have a much smoother implementation path than somebody who just goes about it all scattershot. The investment that you will make in month 1 is going to pay dividends for the rest of the implementation. Okay, policy development, day by day. We're going to get really granular with, particularly with the early implementation stuff. Days 1 through 3, assess your current state. Send an anonymous survey to all your staff. Ask who's already using AI, what tools are you using, what purpose are you using them for, what concerns do you have. This will give you a baseline to understand where you're starting from and reveal any hidden usage that you might not know about. Days 4 through 7, draft your policy. There's 7 key components that we'll detail a little later, but in summary, permitted tools, prohibited uses, use case risk classification, verification requirements, client disclosure protocol, billing guidelines, and incident response. Week number 2, review and finalize. Get input from your other key stakeholders. If you're in a partnership, the other partners, otherwise senior leadership, because you need buy-in, not just compliance. Also, get with your malpractice insurance carrier. Ask them, does the policy that you currently have cover AI use? Are there exclusions that you need to know about? Do you need to notify them before implementing? And then check your state bar guidance to ensure any compliance with those friendly folks. Then finalize it, distribute to all staff. You should probably end up with a 3 to 5 page policy document that is clear, actionable, and tailored to the specifics of your business. All right, week 3, it's basic training. Play the Hogan's Heroes theme. That's a prisoner of war camp, but either way, it's catchy. At the very least, you're going to want to have a 2-hour mandatory session for all production staff. Depending on exactly what you're implementing, it may need to be for all staff across the entire firm. You're going to want to cover things like, what is AI? What does it actually do? What are its capabilities and limitations? What are your ethical obligations under the model rules in ABA Opinion 512? This sounds a lot like the first couple dozen slides of this presentation. What does armed firm policy require? What are the verification requirements, and why are they non-negotiable? Apart from the fact that strange man on the internet mentioned it so many damn times that it's going to stick in your head for the rest of the time. Leave time for questions. Don't make it a computer science lecture. Make it practical. Show examples. Demonstrate the tools that you're going to be implementing. Walk through a verification process. And then week 4 is going to be your pilot selection. Again, strike that, reverse it. Week 3 is pilot selection. Week 4 is basic training. Yeah, you want to make sure that everybody understands not just the one application that you've chosen, but understands the underlying principles of how to use AI and how not to use AI. But it will be much easier if you have your low-risk application selected to use as an example. So, week 3, pilot selection, choose one low-risk application. I personally recommend research summarization for most firms as it's lowest risk. There's immediate value that's provided, and it's easy to measure success. Brainstorming is one you can kind of slip in there as well, but that should be more of a ad hoc thing. I suggest identifying 2 to 3 staff members to participate. Look for volunteers who are tech comfortable, but also you want to find somebody who's a little bit cynical. But look for people who are willing to document their experiences, not just people who are going to be sycophantic and say, oh, this was all great. Simultaneously, don't volunteer people. You do want enthusiasm, even if occasionally it's grudging. Then you want to select 3 to 5 matters for testing. Establish your success metrics. How long does this task take now? How long should it take with AI? What quality standards are we measuring? Document your baseline. If you don't know how long research takes already, you can't measure improvement. If you don't have a good handle on your data before you go into an AI implementation, AI is not going to help you get a better handle on your data. It's just going to muddy the waters. Okay, month 2. Execute your pilot. That sounds a lot worse in actual phrasing. Okay, implement your pilot. Week 1, launch slowly. 1 to 2 uses per day. Don't try to do everything at once, but make sure you're over documenting everything. Time spent, outputs generated, issues encountered. Have daily check-ins with the pilot participants. Week 2, increase your usage if week 1 went well. 3 to 5 uses per day. Continue your documentation. Note what works, what doesn't, where the friction points are. Week 3, evaluate. Has it actually saved time? Was the quality acceptable? What problems occurred? What was harder than expected? What was easier? Try and get honest feedback. Don't try. Get honest feedback from your pilot participants. And then week 4, iterate. Refine the policy based on what you learned. Improve the workflow, adjust the prompts, fix whatever broke, and then make the decision. And week 4 may take multiple weeks, depending on how much refining is needed, how much improvement is needed, how much adjustment is needed, before you really feel comfortable making the decision. Should we expand this to the full firm, adjust the approach, or pivot to a different application? It's much, much better to make that decision at the end of a pilot program than to roll something out that's incomplete, only to find 6 months later that everybody's now doing something that doesn't really functionally work. Because ultimately the goal of month 2, however long month 2 takes, is not perfection. It's just to discover, to learn, to build that institutional knowledge about what works in your specific practice with your specific clients and your specific workflows. And that's knowledge that I cannot give you in a YouTube video, no matter whether it's an hour and a half long, 2 hours long, 2 weeks long. Month 3. This is expansion, assuming the pilot was successful. If the pilot was unsuccessful, if he was executed, if the pilot was unsuccessful, go back. Do month 2 over again. But assuming the pilot was successful, week 1, you're going to do a firm-wide training. Everybody gets pulled in. At least all the attorneys and paralegals, again, depending on exactly what the application is, maybe other production, or all firm staff, depending on exactly what it is. This is a mandatory session for everybody. Best to do it probably either a Monday morning or a Friday morning or something where everybody is going to be in the office. Review the policy. If you're fully remote, well, it'll be virtual, but either way. Review the policy, demonstrate the workflow that succeeded in the pilot, show actual examples from your firm, redacted for confidentiality if necessary, but provide written guides and make sure that you answer every question that you can possibly find. Another good thing to do is to have the original pilot group kind of ordained as change champions, such that they can help provide additional support and guidance for those who may have more tactical or operational questions, rather than everybody just coming to you to ask all of their questions, because that's going to become an inordinate burden on your time if you don't. Weeks 2 and 3, a supervised rollout. Everybody is now using the pilot application. You should have daily office hours, or your change champion should have daily office hours for questions. Partners or other operational people should be spot checking their work and make sure that you are documenting issues and successes. Ooh, I'm drinking water now too. Week 4, conduct a comprehensive evaluation. Review the success metrics that you established in the first month. Time saved. Did you hit your targets? Quality. Was it maintained, or did it improve in the work product? Were users more satisfied? Do the attorneys want to keep using this, or did they find it to be more trouble than it's worth? Take that feedback with a grain of salt, particularly if it affects their ability to bill against their billable hour targets, because sometimes they will say that they didn't like doing something, even if it did save them time, because now they're having to do more work to, hit their KPIs. And then do the cost-benefit analysis. What was actual versus what was projected? Did the math work out? And then based on that evaluation, you have to decide what comes next. Do we explore additional use cases? Do we need to look at different tools? Have more training? Scale back or adjust the policy? The evaluation should ultimately be data-driven, though, not based on vibes. Learn to love your data. Everything should be able to come back to asking, what do the numbers say? All right, we're moving into kind of the appendices here, starting with an AI use policy. You will need an AI use policy even if you still don't see the value of rolling anything out firm-wide, because someone somewhere in your firm, as you are watching this, is already using AI without any guardrails or guidance. There are 7 essential components of an AI use policy. I already talked about these a little bit earlier, but we're going to go into this in much more detail. Component 1 is scope. Who does this apply to? Should be all firm personnel, attorneys, paralegals, non-production staff. There are no exceptions. Maybe the janitor if you have a, on-staff custodian, but even then. Component 2, permitted tools. Specify the list of approved tools. You've got, for example, CoCounsel is approved for research, ChatGPT is approved for only internal brainstorming, not client work, Clio Duo is approved for administrative tasks, and update that list quarterly at least, or as you add or remove tools. Component 3, kind of the contrapositive to component 2, is the prohibited uses. Things like never share confidential client information with unapproved tools, never submit AI output to a court without verification, never use AI to circumvent firm policy or supervision requirements, never bill clients for time spent learning the technology unless the client specifically requested use of a particular tool. All these sort of things. This is more of a CYA, cover your butt component, but make sure that it is as comprehensive as possible. Component 4, use case risk classification. Kind of, you can start with the framework that we talked about earlier on. Internal operations requiring basic review, admin tasks, moderate review, client-facing work, extensive verification, etc., etc. Define who approves each risk level. A solo attorney, approves internal use. The senior attorney approves solo attorney. That doesn't make sense. Associate attorney approves internal use. The senior attorney can approve client-facing use. Whatever makes most sense for your structure. Component 5 is client disclosure protocol. When is disclosure required? When is AI use material to the representation, or if it significantly affects the work product? How is disclosure made? Maybe it's in the engagement letter provision, or there's a separate written disclosure before the matter. Document the disclosure. Make sure that it's uploaded to your practice management or CRM, so that, again, if anybody comes to ask, you've got it written down. Component 6, billing guidance. Bill for value delivered, not hours saved. Be transparent about AI use if it significantly affected the time spent. Don't bill your full hourly rates if AI cut time by 70%. That's unreasonable under Rule 1.5. Hashtag not your lawyer, not legal advice. Consider flat fees or value-based billing for AI-assisted work if it's relevant and acceptable within your state bar guidelines. Component 7, most important one, I keep harping on it, verification protocol. You've got to have a mandatory citation checking for all legal outputs, substance to review for accuracy, documentation of verification in the matter file, define consequences for skipping verification because someone will try. There is no point in putting up, this is a terrible metaphor probably, but there's no point in putting up fences if they're not electrified. Because otherwise you can just keep trying to jump them until you succeed. Policy should probably be 3 to 5 pages. They need to be clear. It needs to be clear, actionable, and specific to your practice, not just a generic template that you downloaded. That's why I'm not providing any generic templates in this video, or as deliverables from this video. It needs to be about your firm, your practice, your specific tools, and your specific workflows. All right. Some common implementation pitfalls. Got 7 common mistakes to stand companion to our 7 essential components. First one is not having a clear policy. Everyone does something differently. Inconsistent risk management, partners don't know what associates are doing, whatever it is. It's a recipe for problems. Pitfall number 2, inadequate training. People are going to make errors because they don't understand the tools or the risks. They get frustrated because they don't know how to use the tools effectively. Thus, they stop using the tools entirely. Training pays for itself in avoided mistakes and in, I don't want to say compliance because that's not really the right word, but the embrace of the new tools. Pitfall 3, skipping the pilot. Just wanting to, just go for it. Firm-wide deployment without testing means firm-wide failure when something goes wrong. Instead of learning from small-scale mistakes, you'll find yourself dealing with client-impacting errors across multiple matters. Pitfall number 4, poor tool selection. Being attracted by the shiny objects. If you're paying for expensive enterprise solutions when what you need is something simple, you're just wasting money. Similarly, if you're using free tools that don't have the security you need, you're exposing yourselves to compliance risks. Match the tool to the actual need of the application. Pitfall 5. Honestly, this should be pitfall number 1, number 8, and every other pitfall. Insufficient verification. I'm really going to stop beating this horse, but that's the path to sanctions. If you take the shortcuts, if you skip review, it's going to bite you in the ass. Pitfall number 6, having an overambitious scope. Trying to implement 5 different use cases simultaneously is just going to lead to everybody getting overwhelmed, nothing getting done well, projects are going to get abandoned. Pick one thing, stick with it, run with it, implement it, then move on to the next thing. And then pitfall 7 is not having success metrics. You can't prove that you delivered a return on investment because you never defined what success looks like. Thus, you can't justify continued investment. And the project will die from lack of demonstrable value. Learn to love your data. All of these 7 pitfalls can be avoided by following the structured 90-day plan that we just talked through. Policy first, training and pilot second, then you measure results, and then you expand carefully. And I would be remiss if I didn't give you some metrics to think about as things to track after telling you that you need to track your metrics and learn to love your data. So, 5 key metrics. Metric 1 is your time savings. Track the hours saved per week on AI-assisted tasks. Make sure that you have a baseline before implementing your AI solution versus the actual time used after. You should probably target a 20 to 30% savings on tasks where AI is deployed. Again, that's not going to be across your entire practice because, frankly, that's unrealistic just on the specific tasks where you're using it. In some instances, it may be much greater than that, particularly with drafting and things like that. Tailor your target to exactly where you're deploying AI, but 20 to 30% savings is a good baseline. Metric 2, quality improvement. You want to track error rates. Get client feedback. Have senior leadership review the work product. The target is to either maintain or improve quality. Maintain if you're going to make a meaningful time savings, or improve quality if the time savings is going to be a little bit more marginal. But either way, AI should help, not hurt. If quality starts to decline, something's wrong with the workflow. Metric 3, adoption rate. What percentage of staff are actually using the tools where it's relevant? I want to encourage you to target at least 80% plus within 6 months. If adoption is low, you need to figure out why. Has training not been provided adequately? Are the tools too complicated? What other potential resistance do you need to address? Because this is your money going out the door to pay for these things, and you need to make sure that you're getting the ROI that you're expecting. Then we need to talk about metric 4, cost benefit. Calculate the subscription costs versus time saved times your billing rates. Target, I would say, aim for a positive ROI by month 6, ideally by month 3, but we're trying to be conservative here. If you've got a tool that costs $300 a month and saves 6 hours and your hourly rate is $250, that's $1,500 in value for $300 in cost. It's a 5x return. The math should work. I would say that for any AI application, you should be aiming for at least a 5x ROI. Unless you have a very specific use case that you can actively justify a lower ROI on that. But in general, aim for a 5x ROI. And then the fifth metric is going to be risk incidents. Track the errors that are caught during verification versus errors that escaped. You should be aiming for 0 ethics violations, because one violation, a fake citation that makes it into a court filing, etc., it negates all the time savings. This is your most important metric because, frankly, I've harped on it so much through the last 42 slides, like, you know what I mean. But make sure that you have no errors for anything that goes out to clients. And then document the metrics monthly. Create a spreadsheet, love spreadsheets. Track the actual numbers, not just vibes or impressions. At the 6-month mark, you should be able to show the rest of your senior leadership team concrete data on whether or not this is working. Where to find ethics guidance. ABA Formal Opinion 512, we already talked about. It was issued July 29th, 2024. It is comprehensive, available on the ABA website. Download it, read it, learn to love it. It is your foundation for everything that comes after. Go check your state bar ethics opinions. Do a Google. Go find it. Frankly, if you don't know how to find ethics opinions from your state bar, you don't really deserve your JD. I know I say this as somebody who doesn't have a JD, but I have an MBA and an MA, so it's something. Practice management advisors. Many state bars are offering free ethics guidance through practice management advisors. You can call them, describe your situation, and get preliminary guidance without being reported. Make sure that you use that resource if you're not sure about something. And then go look at Mr. Damien Charlatan's AI hallucination database. It's damiancharlatan.com/hallucinations. He has been tracking all documented cases of AI hallucinations in court filings globally. It is regularly updated. If you want to stay current on sanctions cases, either to provide updated evidence for your staff or just because you find it amusing, there's your resource. Tool comparison and training resources. Websites are all located here. Pause. Go look at them as you like. Free trials. Most reputable or legitimate vendors should offer some form of trial, typically 14 to 30 days. Don't commit to annual subscriptions without trying the tool first. If somebody does come forth and try and say, oh no, we only offer 1-year commitments, that's a big red flag. One critical note, the landscape is changing rapidly. I tried to stay fairly tool agnostic and focus on principles so that this video does have longer shelf life than a head of iceberg lettuce or Liz Truss's prime ministership, but always check publication dates on any resource. A tool review from 2023 is outdated. Look for, at best, the back half of 2025 or 2026 published materials. All right, concrete actions for week 1. We're almost at the end. If you're still watching, we're almost 2 hours in, so thank you for sticking with this. Concrete actions for week 1. Monday, conduct an anonymous survey, Google Form, SurveyMonkey, whatever is easiest for you. 3 questions. Are you currently using AI for work? If yes, what tools and for what purposes? What concerns do you have about AI use? That's it. Send it to everyone. I think I talked about a slightly more expanded one earlier on. If you want to do a more expanded one, go back to, about 20 minutes ago and listen to that. But make it anonymous so people can feel comfortable to answer honestly. Tuesday, go find Formal Opinion 512, as well as your state's AI guidance. Read them, learn to love them, internalize them, because they are your compliance baseline. Highlight the sections that apply to your specific practice area. Wednesday, get in touch with your malpractice insurance policy or provider to review your policy for AI coverage. Look for exclusions, notification requirements, coverage limits. If it's unclear, and let's be honest, they're insurance policies, they usually are, call your carrier. Ask directly, are we covered for AI use? Do we need to notify you before implementing? What are the exclusions that we should know about? Thursday, identify 2 to 3 potential pilot participants, both amongst your staff members and pilot softwares. Have some informal conversations, gauge interest. Don't mandate participation with your internal staff, because you want people that are willing, if not necessarily strictly volunteers. But don't volunteer people. Anyway, Friday, and then schedule your policy development meeting. Block 2 hours at least. Invite your key stakeholders, senior associates, whoever needs to be involved. Go over the ABA guidance, discuss the survey results, and begin drafting your policy framework. Next Monday, start drafting your use policy. Use Opinion 512 as a template. Customize it for your firm. Focus on the 7 essential components we discussed earlier. That's week 1. And actually, the start of week 2. It's not complicated. It's not overwhelming. Just 1 action per day will get you started. Okay, let me recap what we've covered in the last 1 hour and 53 minutes. AI is pattern recognition, not magic. It's just sophisticated autocomplete at massive scale. It's very useful, but it is not thinking, it is not reasoning, and understanding that limitation is critical for making sure that you use it effectively. Current tools that are available as of the end of Q1 2026 are useful but imperfect. Verification remains mandatory because even the best tools make mistakes. Understand that your competitors are adopting. 79% of legal professionals are using AI in some way. 80% expect to increase their usage in the next year. The question is no longer whether to adopt, it's whether you adopt strategically or reactively. The ethical framework is also evolving, but clearly being laid out and developed as time goes by. Opinion 512 provides comprehensive guidance, but it isn't binding. There are 6 core areas: competence, confidentiality, communication, candor, supervision and fees if they could have found a way to make those last two. Actually, let's see. Competence, confidentiality, communication, candor, supervision could be compliance, and fees could certainly be costs. So anyway, we've got our 6 C's there. State variations exist, but the principles are established. There are plenty of low-risk applications out there. Internal ops, administrative tasks, supervised client work. You don't have to jump right into the medium or the high-risk applications. Start where the risk is lowest, where you're comfortable, and where the value is clearest. Implementation is going to be methodical. It's got to be like a 90-day minimum. I know I said it's a 90-day roadmap. Some of it may happen more quickly, but don't rush it. You've got policy development, you've got your controlled pilot, and then you can move into a measured expansion. This isn't a blanket order to everybody, just download ChatGPT and start using it. It's a structured, careful implementation with verification at every single step. Because if you want to be successful in this, and I think that if you want your law practice to survive and thrive through the rest of the 2020s and into the 2030s, it is necessary. Success is going to require discipline. Verification is not negotiable. Supervision is mandatory. There are no shortcuts. The one thing that will kill this entire project is cutting corners on verification and ending up with a fake citation and a court filing, and then getting whacked with the very, very big naughty stick. So, final thoughts. Skepticism was warranted 3 years ago. Tools weren't ready. There were not any independent benchmarks. It was all just vendor hype and, TED Talk enthusiasm. If you were skeptical then, you were right to be. But that was 3 years ago. Things are different now. The tools have matured. We have independent benchmarks. We understand the risks and how to mitigate them. The ABA's released guidance. We've got 912 and growing cases of what not to do. We have enough data to make informed decisions. The question is no longer if you adopt AI, it's about how and when, because the competitive pressure is real and it's just getting stronger. The efficiency gains have been documented. The ethical obligations around technological competence are clear. Pretending that this isn't happening isn't going to protect you or make it go away. It's just going to expose you in the long run. So, here's what I want you to do. Start small. Pick a low-risk application. Like I said, legal research summarization is my recommendation for most firms. Build your confidence, develop those verification habits, and prove that the concept works in your practice. Then verify everything. Every citation output, no exceptions. I say I cannot emphasize this enough. I think I have. But the difference between successful adoption and a sanctions case is verification discipline. And then expand gradually. Don't do everything at once. Don't be all things to all people. Once your pilot is successful, then you expand the principles of that to your full firm. Once your full firm is successfully onboarded, then you add use cases. Step by step. Go back and do it over and over again. But you have to understand this. And again, hashtag not your attorney. This is not legal advice. Your malpractice risk is higher from not staying current with technology than from competently using new tools. Depending on your reading of Opinion 512, I think it's pretty clear that it makes technological competence an explicit requirement. Ignoring AI is not going to protect you. It just exposes you to claims that you failed to use available tools to serve clients efficiently. Kind of like if you build clients twice as much for drafting because everybody was using an IBM Selectric instead of Microsoft Word. We've got our 90 days to responsible implementation. That's what we've just laid out. Month 1, policy and training. Month 2, controlled pilot. Month 3, measured expansion. Start this on Monday morning. Your Monday morning action, and this is all that I'm going to ask you to do right now, then come back and watch the video again. Send the anonymous survey. Just start there. Are you using AI? What tools are you using, and what are your concerns? Everything else follows from that first step. Because the survey results will inform your policy will inform your training will enable the pilot will generate the data, and the data will drive the expansion. One final thought, and then we're done, and we might make this exactly 2 hours. AI is never going to replace lawyers, but lawyers who use AI will replace lawyers who don't. It's not a threat, it's just an observation about how technology adoption works in professional services. The firms that figure out how to use these tools responsibly will be more efficient, more profitable, and more attractive to clients and talent. The firms that don't will fall behind. But, and this is crucial, it is only if you use it responsibly. That's what this entire presentation has been about. Not oh, go use AI. Everybody's going to use AI. The question is whether you use it competently with appropriate safeguards or whether you use it carelessly and end up in a federal court opinion as a cautionary tale. You now know what to do. You have the framework, you have the 90-day plan, you have the tools list. You have the verification protocols and the week 1 action items. So go do it. Thanks for watching. Have a good night and a good tomorrow.